Williams Show on WKAC.
Okay, we're back with the Dan Williams Show. We have a comment from a call-in. Thank you, sir, for calling in. What's your comment?
Yes, sir. My name's Michael. I was a member of the Family Law Task Force 2008-2010, and one of the questions I had was, where did best interest of the child come from, and what is the definition? And there is none. It came from a the United Nations Children's Act that they've been trying to pass, and there is no clear-cut definition of what best interest of the child is, and maybe your guests can tell me that. Thank you.
Okay, thank you for the comment.
You want me to answer the history about that?
Yes, ma'am.
Go right ahead, yeah.
Okay. There was an outgrowth. Well, originally in our history in the early 1900s, the father automatically had all rights to the children. And then the tender years concept was adopted, where it was presumed that the mother was the better parent and that the children, through at least age 13, would automatically go to her. Well, that was also rejected. This pendulum had swung too far in the other direction. And so then around the 1920s or so, maybe a little later, then they developed the concept of the best interest of the child, so that neither parent was presumed to be the better parent, and that an evaluation would have to be made. And so that's why the whole cottage industry of forensic evaluators developed, where they would do an evaluation to determine who was the better parent. And that's how that developed. I think we have to move beyond the best interest of the child and have a new concept of joint custody, make it work.
Joint custody. Go ahead, Mark.
Linda, you talked earlier about, we've been talking about parental alienation, and I'd like to know what your comments are about how to reverse the effects of that.
Okay, well, alienators generally do not self-reform. I wrote about 32 alienated cases, and in 16 of those, the alienation was reversed. And I have to say, when I began the therapy, virtually every child had absolutely no visitation or connection with their alienated parent. The relationship was generally severed. What usually has to happen, I work very closely with the lawyers for the child where I work. If I can get the lawyer for the child to tell the alienating parent, I suspect alienation, you better cooperate with Linda's therapy, because alienation is grounds for transfer of custody. And it's absolutely true. Most states have on the books already that interference with the relationship with the non-custodial parent is so detrimental to a child's best interest that it's grounds for transfer of custody. When the courts threaten that that's what the remedy will be, that's when I've been able to reverse the alienation. And I do it in a number of ways. I reach out first to the alienating parent. I attempt to get their cooperation. I give them research about the detrimental effects to children when a parent is eradicated from their lives. And if I have to threaten that I will recommend transfer of custody if the alienating behavior doesn't cease, then I will threaten that. I tell everybody I want to go forward. I don't care what either party did in the past. If the two of you are willing to co-parent and work effectively together, that is my concern. But I will use the courts, and unfortunately, that is virtually the only remedy that really has an effect. Fear of court reprisals, either loss of time, either financial penalties, incarceration, or ultimately transfer of custody.
Linda, in the state of Alabama, I know from reading appellate court cases that they will not recognize parental alienation. I think there was one case that came out where it was really severe, but many times we'll have this alienation that's on the mild side.
I don't call it alienation anymore.
Okay, what do you call it?
Parental interference by one parent with the relationship with the other parent. That is observable. That can be documented. And that behavior is on the books in most states. We have to use a different terminology.
Yeah, okay.
Parental interference with the relationship with the other parent. It is the responsibility of the custodial parent to facilitate the relationship with the non-residential parent. That is on the books in virtually every state, and we need to enforce it.
Okay.
I don't call it alienation anymore.
Yeah.
I've gotten away from that.
Yeah. Let me ask one other question before we got just a few more minutes. Linda, I wanted to ask one question. Divorce may be so easy. I see billboards around $199 divorce, no hassle, no anything. In those situations where divorce is so easy, shouldn't there be, maybe we're looking at preventing alienation by not being so easy for couples to be divorced, and then some settlement has to be made about a child. What about couldn't we make parents that's filing for divorce where children are involved go through some kind of situation to try to solve the problem before this child is just thrown into the court system and wind up in all these problems like we've been talking about? Is there any credibility to that?
Well, that's why I said in my book that child custody should be mandated to be resolved in a collaborative model or a mediation model. And for example, in California, before a divorce case can proceed, when there are children involved, they mandate counseling, special counseling for the parents and for the children, so that they can educate the parents about what happens to kids if they are used as ammunition in the war called divorce. If they do become the house in that movie, The War of the Roses, which of course was symbolic. The house was symbolic of the child, but you can't destroy a child for a movie.
Yeah.
That absolutely is effective. And when the children come together in their group therapy, they're asked to draw pictures of what is happening in the family, and the parents are given feedback as to what their kids are saying. That's one of the very effective tools I use in family therapy, which is another reason you need family therapy. I will get the children to tell their parents what they are doing to them. I've had children say, "Will you please solve this with Linda already, because all your money for our college is lining the pockets of your attorneys."
Yeah.
Or, all sorts of things. So there are many different ways that a family therapist can intervene. I often have the alienated parents bring to the session photographs and videos and everything that they did that indicated how they were involved in their children's lives before the onset of the separation, because these kids have been brainwashed to believe their other parent was never involved with them.
Yeah.
So that's a very effective tool also. And once these children are given permission by the alienator to be in touch with their loving feelings, they will flip like a light switch and accept their other parents, because their rejection is not genuine. I've had children, just say, "Okay, Mommy, okay, Daddy, I'll go on a visit this weekend," because that parent has said, "It's over. You're going with your father, who you haven't seen in a year. Or you're going with your mother, who you've cursed out and kicked." As soon as they're given permission by the alienator, those kids will flip like a light switch. So this is nonsense. They're going to commit suicide. They're going to run away. I mean, I worked with the foster care population for 24 years. Thousands of kids. Not one of these kids who were genuinely abused and neglected ever said, "I hate my parents. I never want to see them again." We have to realize how anti-instinctual it is in divorce cases that these kids are mouthing these words that have no credibility and no support.
I know we just got a couple minutes left, and I want to mention one thing here, Dan, that there's a joint custody bill in the Senate right now, SB 408, and just want to list out the factors that what this bill provides. It provides for the rebuttable presumption in favor of division of equal time between two parents with their children. It requires the parents to create a parenting plan. The court may order the parents to undergo mediation or co-parenting educational classes to assist in the development of the parenting plan. It will require the court to list written findings of fact. It does not change anything about Rule 32 on child support. If there's been a prior conviction of child abuse, kidnapping, and that type of thing, then the existing domestic violence code will apply. It'll remedy custody interference, and then, of course, the passage of the bill will not serve as a material change of circumstances to modify existing custody.
Yeah. Well, I think, Linda, we're out of time, but I want to thank you for calling in, and you've given us a lot to think about. And I like what you said there to end with, that cooperation between the parents.
My pleasure. And tell all your listeners to go to my website. It's free. It's a wealth of information.
And what is that address?
It's www.endparentalalienation.com.
Yeah. Okay. We'll do that. And Linda, we certainly appreciate you calling in. It's been good to hear what you had to say, and we hope to see you again someday.
My pleasure. Thank you.
Thank
Bye-bye.
you. Mark, it's been a good show, I think, with getting an expert like that to call in, and she's given us a lot to think about, and a lot of good information. And
appreciate you allowing us on. Thank you.
Yeah, and anyone in our listening audience that you fall into this category with family problems and children, and child custody, take a look at that website, and also the Alabama Family Rights Association has a lot of information. Just look them up. But we appreciate you tuning in. We'll be back next week with another Dan Williams Show.